Well, if you think you're facing a job loss, you need to know your rights as an employee. Many of your rights are protected under something called the WARN Act. Here to explain is Rene Roupinian. Rene is an attorney with the law firm of Outten & Golden in Stamford and New York. She specializes in employment law. Rene, good to have you in the program.
Thank you. Good to be here.
The WARN Act is now the WARN law. Explain to me what it entails.
It's a federal statute, although there are state counterparts, and it's a notice statute. So essentially it means that an employee is entitled to 60 days written notice before a plant closing or a mass layoff. So 60 days written notice that you're going to lose your job, and if you're not given that notice, chances are you're entitled to 60 days pay and benefits in lieu of the notice.
So a plant closing, but now what if your company is just going to lay, let's say there are 300 employees in your company and they're going to lay off 60. Do you get 60 days notice in a situation like that as opposed to a complete closure of an operation?
Well, it would depend on whether the federal law or the state law would apply. In some states the threshold is much lower, but if those 300 individuals work at one location where you work, where this specific employee worked, and only 60 people were laid off, then the threshold would not be met under the federal statute. It has to be at least 50 full-time employees representing a third of the employees that worked at that location. So unfortunately, the federal statute is not as strong as we would like it to be, and in that instance, you would not be entitled to the notice that is normally required if, in fact, a mass layoff had occurred at that specific location.
What does the notification have to say?
It has to tell the individual when their layoff is expected to occur. Ideally 60 days going forward from the date that the notice is received. It has to provide for a point person at the office or the employer where they can contact for further information. And if, in fact, they're not given the full 60 days notice and the employer is trying to take advantage of one of the exceptions to shorten notice, then the notice also has to provide a reason for less than 60 days notice being given. And that reason has to stand up in court because the employer will have the burden of proving that that reason essentially holds water, that they were not obligated to give the full 60 days notice to the employee.
And there are some legitimate reasons, at least recognized by the WARN law, that don't require the company to give you that 60-day notice. What are some of those certain situations?
Well, there's essentially just two defenses to giving less than 60 days notice, but it doesn't obviate the employer from giving notice at all. It just says to the employer, you don't have to give the full 60 days if in fact one of these two defenses applies, but you have to give as much notice as is reasonably practicable. And the defenses, the two major defenses, are what we call the unforeseeable business circumstance defense. So if some sudden dramatic event happens outside the employer's control, for example, a major strike or a major customer cancels their account with the employer, that would be essentially an unforeseeable business circumstance. If in fact it was unforeseeable, if the company had no reason to know that this contract would be canceled. Or
a tornado sweeps. I mean, we see that happening. They wipes out a plant or a business. It's an act of God, so to speak.
Right. Well, that is the only that's the only time when a company is not obligated to give any notice. But then the law still says you have to give after the fact notice. You at least have to give notice to the employees to tell them essentially this is why the company shut down and we weren't able to give you advance notice. But the other major defense is the faltering company, and that essentially means that they were trying to get new business or capital, and had they given the employees the notice that was required, it would have jeopardized their ability to do that.
What if a company files for bankruptcy? How does that affect their need to file?
Well, that's interesting, and I'm glad you asked the question because I'm sure many employees think my company closed up shop and went into bankruptcy.
Right.
I have no recourse. What am I going to do? But that's not the case. Bankruptcy courts, by and large, do recognize these claims, and the employees, because it's a wage claim, it's 60 days wages plus benefits, do give the employees a priority above, say, general unsecured creditors. So it's a technical, the law is technical in and of itself, but it's compounded by the fact that a company does go into bankruptcy. So that's why it's important that if you think you have a claim, that you contact a lawyer and just explain to them the situation and ask them whether or not they think they can bring a claim for you in the bankruptcy court.
I know I'm asking a lawyer this question, but do you need a lawyer, or is this something that can be handled by, for example, the state of Connecticut?
Actually, the federal law, unfortunately, does not provide any enforcement ability to the Department of Labor. The only recourse for an employee is to retain an attorney and bring a claim. and they can bring that claim in federal district court or in bankruptcy court if the company is filed for bankruptcy.
Can you do that as a group? Because oftentimes what you're going to pay an attorney supersedes what you're going to recoup in the 60 days in wages and coverage.
Yes, these claims do lend themselves to bringing them as class action cases because, as you can imagine, the individual damages are relatively small. You're talking about 2 months' pay and benefits, and it's going to cost you more typically to pay an attorney to bring a claim than the recovery. So these cases are typically taken on a contingency fee, which means you don't pay any attorney's fees unless you recover, and then it's a percentage of the recovery and as a class action, so a large group of employees would bring the claim together.
All right, Rene Roupinian, good to have you on the program.
Thank you. It was a pleasure to be here.
From out in Golden in Stamford and New York, and we'll be back with more 12 on the Money after the break.